Today's a big day, big red letter day. We got a hearing in San Francisco that's going to happen later this afternoon in front of Judge Breyer, Charles Breyer, who's presiding over the case that's been filed by the state of California about whether Donald Trump's attempted takeover, commandeering of the state National Guard, use of federal troops on domestic soil is right or wrong, whether it violates the Constitution and the 10th Amendment of the Constitution, because it violates sovereignty and the powers that have been reserved for the people and for the states in our system of federalism. That hearing, which I'll cover after it's over at 4:30, but the start of those issues is filings by and briefings that have been ordered by Judge Breyer, who initially refused to grant a 72-hour stay, but instead set a very fast track for the parties to submit their briefs. We've got the Trump brief in, the Department of Justice brief in. Later today, later this morning, in about an hour or so, we'll have the final brief by the California officials. And then at 4:30 Eastern time, we'll have the hearing. I'll try to get more information about the hearing. I may even try to zoom in to the hearing to be able to report on it. But let me just talk about what's just happened with the filing with the Trump administration. I'm Michael Popok. You're on Legal AF. I think you come here in order to hear me criticize things like this. I got to the table of contents and it was blank. And more importantly, I got to the table of authorities for the Trump brief, which is where you're supposed to list all the case law and precedent that you're relying on. And maybe as a little bit of a subliminal message, they're signaling they really don't have any legal support, because where there should be the law listed, it just says insert. And this highlighting was actually what was filed by the Department of Justice. All right, let's put the sloppy thinking aside for a minute, although I'm sure the judges and the law clerks were shaking their head. When you read their opposition, such as it is, it starts with a political attack on Gavin Newsom, one of the leading political rivals of Donald Trump, who's battling it out because he's been attacked and his state's been attacked in public. It starts with a political screed. It sort of ends that way, and it has very little in the middle as in terms of case law. The primary argument here raised in the complaint is that the only way for a president to commandeer the state militia, the state National Guard, is if there's a expressed statute or constitutional provision that allows for it. So you go to the statute book, and there's only two on the books. There's the Insurrection Act, which Donald Trump, although he's used the language of insurrection, he said, I'm not invoking. Okay. Then he's only invoking a statute. And that statute, which we've gone over at length, which resides in Section 10, the 10th chapter of the U.S. Code, 10 U.S.C. 12406, it's a very dry way of saying there has to be 3 requirements in order for a president to exercise the right to commandeer the National Guard under 12406. None of them are present. There's no rebellion going on against the federal government, as that term has been used historically. Trump isn't having trouble faithfully exercising or freely exercising the laws that he needs to execute. He's got law enforcement on the ground that would help him. He's got police. He's got ICE. And so none of those factors apply. Yeah. And so the only thing that he's left with is to try, and he didn't ask for the governor's approval, which is also a factor in the 12406 analysis. So that's over. No statute, no Insurrection Act. And now you're left with a body of Supreme Court precedent, which supports the 10th Amendment of the Constitution, which all is against Donald Trump. Here's how he starts his filing that the judge is going to consider. In a crass political stunt endangering American lives, the governor of California seeks to use this court to stop the president of the United States from exercising his lawful statutory and constitutional power to ensure that federal personnel and facilities are protected. And then they go under, but as the commander-in-chief of the armed forces, he's responsible for ensuring the protection of federal personnel and federal facilities. And that they then go on to say that the LAPD has been unable to bring order to the city. I don't think that's true. I think if the feds would back out, the LAPD would be able to control the situation there. I mean, there's been 600 arrests, but that's through law enforcement. After that introduction, on page 2, and then walks through the National Guard system. When it gets to the section on 12406, it just skips over it. It just says, well, it exists, and we make the determination. The president makes the determination as to whether there's a rebellion. He says there's a rebellion. The president makes a determination as to whether he's having difficulty executing the laws. He's having a difficulty executing the laws. You can't challenge it. This is the same approach that Trump has made, sometimes successfully, sometimes not, because he's lurching from one fabricated, manufactured emergency to the next. Why? Because he wants to use these war powers, these emergency powers, without being challenged. But that's not how they work. Even under the Alien Enemies Act or under the Insurrection Act or here under these statutes, the determination is first made by the president, but subject to the review of a federal court and ultimately the United States Supreme Court. That's checks and balance. That's checks and balance. So they ignore all that. They talk about the riots and violence in Los Angeles, pumping up this false narrative. A riot, if anything, that they caused. The deployment issue. And then when they get to the part about, hey, even though the statute 12406 says you've got to go through the governor. We spoke to the governor. It says the orders have to go through the governor, but, we put his name on it. We said to from the governor. We're good now, right? Under 12406? No. And then when they look at the 10th Amendment, their analysis there is no better. They mischaracterize the first, the major case that concerns the 10th Amendment, completely missed the boat on that one. They start citing to cases back in 1919 and 1827, which again I've read and they have mischaracterized. And they're asking the court to back off, that there's no ability to veto by the governor, that the federalization of the guardsmen did not intrude on state powers, and that there's nothing to see here. And that if there is an injunction, there should be a bond, some huge amount of money that needs to be posted by the state, signed by Brett Shumate, who is the guy that was in private practice, I think at Paul Hastings in California, pressed into action like the next day after the swearing in, joined by a bunch of other people I've never heard of. Some people that are still left in the United States Department of Justice in Washington have also signed. And now we're waiting on the next brief, which I'll do a separate hot take on. That'll be the last word by California. We expect that in the next hour or so. And then there'll be the hearing this afternoon. I think the judge, 83-year-old brother of Justice Stephen Breyer of the United States Supreme Court, this is a hard decision he's going to have to make about whether the 10th Amendment has been violated, reserving all power in the states and in the people except those expressly given to the federal government. The commandeering body of case law needs to be adequately analyzed. You're not going to find it in the Trump brief, so it's going to have to be left to the California to carry the water on this one. And then he's going to hear oral argument. And we're going to get either he needs more briefing, either he's going to issue an administrative stay for his temporary period of time, or he's going to not issue a stay and just rule on it in due course in the next few days. Whoever loses, is taking it to the Ninth Circuit Court of Appeals and then to the United States Supreme Court. But that's where we are right now with the filing of the Trump administration. Don't see this as a winner at all. Let me take a look at and I'll post this up on Substack. Let me take a look at the next brief that comes in. And then, of course, I'll report on the oral argument. This matters. It's not just about California. It's about our federation of states. It's about our union. It's about what this rogue, lawless president can do to attack his political rivals and punish blue states. This is the Harvard moment, but now writ large for our entire constitutional republic. And I'm here for it, and so are you. Take a minute, hit the free subscribe button. Bang, you're now subscribed. You'll get reminders now for all of our postings. We've got over a dozen contributors here on Legal AF and on the Midas Touch Network. Come over to Legal AF, the Substack, where I post this type of things along with commentary, so you can download it along with analysis and writing you can't find anywhere else. Legal AF, the Substack. And then we got Legal AF, the podcast, every Wednesday and Saturday at 8 p.m. Eastern Time. So until my next report, I'm Michael Popok. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.